So when a person signs a healthcare proxy, what authority does that healthcare agent have? Well, first of all, folks, let's discuss what a healthcare proxy is again. I've actually discussed this in previous videos, which you'll see the links to those previous videos inside the description of this video. First of all, now, we have to understand that a healthcare proxy falls under the term advance directive. And with an advance directive, basically you can think of this as a person giving direction in advance of an event, right? And in advance of them getting sick. And with a healthcare proxy, this is a written agency that is created in which a healthcare agent is designated by an individual. And so you have the terms like principal, who's the person that makes the document, and agent, who's the person that has been designated to take the authority, take charge, if the principal, the maker, gets sick and cannot make their own decisions medically. So now who can serve as an agent? Well, basically it's any competent individual that you know and trust, that knows you. Could be a friend, family member, loved one, to serve as your agent. Who can't serve would be employees of the facility that you're being treated at. For obvious reasons, there could be a conflict of interest there. And there's an exception to this rule, of course. If you have a blood relative, a loved one, someone who's related to you in some way that works at the facility and is designated as an agent, then there's an exception to the rule. Also in this document, this healthcare proxy, you're going to designate not only a primary agent, but you're going to designate a backup agent, an alternate agent, in other words, in case your primary agent isn't able to serve. And the same rules apply to the alternate agent as to who can serve on your behalf. And in Massachusetts, anyway, the statute designates or determines that you can only have one agent at a time. Once again, for obvious reasons, you don't want to have a conflict of interest and a doctor listening to two individuals at once. So it's one person at a time, and you designate a backup agent. Now, in general, your statutes or your laws that dictate the way a healthcare proxy should be written give the agent the ability, a broad discretion, a broad way to act. And in Massachusetts, anyway, there are two doctrines that are working simultaneously. The first doctrine is the doctrine of informed consent. And with informed consent, that basically means that a patient is entitled to receive all reasonable information that may be available at that point from the doctors in order to make an informed decision. Now, your agent stepping into your shoes would receive that doctrine or receive that whole situation with informed consent and be able to make an informed decision. And then the next doctrine that comes into play is that called substitute judgment. And with substitute judgment now, it's your agent stepping into your shoes because remember, you don't have the ability to make the decision. If you did have the ability, the healthcare proxy would not be in effect, right? So with substitute judgment, that basically means that your agent steps into your shoes, takes into consideration all the information that's presented by the doctors, and also has a bit of a duty to look into other types of treatments that you might be able to receive instead of what's being proposed, and look at the diagnosis. So all of this information is going to be made available to the agent. So the agent, whom we presume would know the maker pretty well, or very well, would, based upon the information that's provided to them, the wishes of the principal, the maker, and the religious beliefs of the maker, the agent would then make the decision based upon what they receive for information. And there is a broad range of powers that the agent's going to have with respect to treatments. And there's only a certain limitation in Massachusetts, or limitations in Massachusetts. One of those big limitations that an agent cannot do is to admit an individual into a nursing facility, because now this is taking the next step where a judge may need to be involved. Also, there are limitations that can be set forth by the principal inside the document. Or if there is a court determination as to what those limitations are, the agent's got to follow that. Now, with respect to the agent's liability, let's say the agent makes a decision on behalf of the principal, right, the maker, and the agent is worried about possible ramifications or possible exposure down the line from the principal, from the maker. Well, as long as that agent is acting in what we say as good faith, meaning they received all the information, they took all the considerations into their decision-making process, along with what the principal would like and the principal's religious beliefs, as long as all of those things are taken into consideration and a decision is made, the agent is free from liability at that point because they're acting in good faith. In other words, without malice, without bad intentions. So those are some of the powers that a healthcare agent will have. Now, the healthcare document itself, the proxy, may be revoked or terminated by the maker at any time. And it's pretty informal in the way that it could be done. It could be done in writing, it could be done orally, it could be done with a written notice to the agent that the principal or the maker no longer wishes to have that person as their healthcare agent should something happen down the line. But still, this is a great document to have in place. And without this type of a document, friends, family members, loved ones would need to approach the probate court for a guardianship over that individual. So a guardianship is a court proceeding where loved ones, friends, family seek to take care of or get authority to act on behalf of another person, maybe a family member, and care for that person's their well-being, their medical procedures. That's what a guardianship is all about. That would be necessary if there was no healthcare proxy in place. And that most likely will be the type of a petition that will be filed in the court if there's some type of a challenge down the line to the healthcare proxy that was signed by the maker. Now, if you're watching me on Facebook, make sure that you subscribe in the lower right-hand corner. Also, be sure to check out some of the videos that will be appearing here. Also, be sure to check out some of the links that I have included below in the description of this video. And if you're watching me on YouTube, they'll be below. If you're watching me on Facebook, they'll be above. Make sure you check all those out. Dave Ceruolo, CeruoloLaw.com.